hang on just a second, let everybody get settled. Are my eyes failing me, or were you doing recon yesterday?
A return?
Are my eyes failing me, or were you doing recon yesterday?
I was reconning, Judge. I got to tell you that I've been practicing 30-something years, and this is my first time here, and this is quite the intimidating place for even an
No harm. My bifocals are getting worser and worser, but even in the midst of all those people, your face looked familiar from yesterday, so.
I want to say this. I must have stood out because there were a lot of people there.
I'm just saying, I'm just testing my bifocals to see if I got it right. I'm like, looked like I saw him in here yesterday. But anyway, just teasing. All right, Mr. Wilkerson, you're up.
May it please the court, opposing counsel, and good morning. And I do want to start with saying that I appreciate very much the opportunity, and I'm humbled by the opportunity to be able to argue this orally. And I'm going to say something that's going to sound arrogant at first, but then tell you this with all humility. When this case went to the summary judgment with the district court, I thought it was a no-brainer. We found what I thought was the servitude, the navigation servitude at 65 feet, seasonal flooding above that. Our expert says there was no way that anything of commercial value, agriculturally or grazing, could grow there. We had evidence that with 55 feet, the servitude was 65 feet. I thought there's no way we can lose this thing. I wasn't being cocky about it, but I thought we were going to win. And then we didn't. And I still think that it's that big and that strong of a case. But the reason the humbleness of it is this, that I realize a very smart judge, some very intelligent counsel vehemently disagree with me. I know that a district court in the Ford City case ruled in what would be their argument, and that an expert that was hired was looking for an ordinary high water mark the same way that they're looking for it. So I know that very smart people see it a different way, and I hoped that we could have oral arguments because I felt like this needed to be fleshed out. Maybe it doesn't, but I felt like it did. I want to say that I think that this might, after reading hundreds of hours of cases, and believe me, I have, it sounds like to me that the problem is that when they have the wrong definition of seasonal flooding, and ours is what I think is the right way, but I understand there's another way that people see it. I see it as there's permanent flooding. On top of permanent flooding is ordinary flooding, and it's out at angles. So it gets wider. And then on top of the ordinary flooding is extraordinary or above ordinary, which is seasonal. So you can't get to the seasonal until you get past the permanent, past the ordinary to seasonal. And so that gives you a result where the Corps of Engineers has a navigation servitude all the way out to the banks where terrestrial vegetation, and if I say terrestrial vegetation, leave out agricultural and grazing, please know that I understand that there's three things. But that it goes out at an angle like that, and that when it reaches that point out here at the level where terrestrial vegetation can start to grow. So if you're going from the bottom up, terrestrial vegetation can start to grow. That's seasonal. You're still in a wetland situation, but it's seasonal flooding. I think that from looking at the statement of the best laid plan, there we go. Their statement regarding all arguments, that's where I found they defined best what they're calling seasonal flooding. They said, appellees respectfully suggest the court to forego argument because the appellant's proposed expansion of the navigational waters of the United States to include a pipeline right-of-way, which is dry land, on average of 67% of the year. So they're going by a percentage, mathematical, subject to seasonal flooding, only inconsistent with well-established federal law that excludes, here we go, from the reach of navigable waterway. Wait, I missed it. Subject to seasonal flooding only. There's what it was. I went over it. So they're saying seasonal flooding only, and they're calculating it by how long it's there. And just to get ahead on a little bit of an argument, but that 21.54 acres, Kelly's Creek clearly says that you cannot find the ordinary high water mark using arithmetic, mathematics, that it's a mark on the ground, and it's a point where terrestrial vegetation can no longer survive. That's what we would be looking for. But when they take their definition of seasonal flooding, then it's as soon as it's no longer permanent. And it creates, their ordinary high water mark is the same as what really would be the ordinary low water mark, which is where there's permanent flooding. It never gets dry there. So nothing can grow. So that creates for them, which would lead to the three things that I would like to discuss, if possible, if we have time. One is that that both the district judge and opposing counsel put the ordinary high water mark at the edge of the low water mark. So there really is no difference between the low water mark and the high water mark. They just completely skip ordinary flooding. So that creates a situation where they're saying that the Corps' navigation servitude ends at the edge of that bank. And I want to talk about what that would do to the, I think would do to the jurisprudence and how the Corps, just exactly how the Corps works, how it operates. Then the second thing I'd like to talk about is that 65-foot servitude, the Corps retained, when they decided, well, first of all, that started out as a navigation project. That navigation project authorized them to get that servitude. Again, you look at, this is where 21.54 acres says that if you raise the pool stage, you got to raise the ordinary high water mark. It's going to happen each time. It's by definition that's going to happen. So that's what happened, and then the Corps says they need 65 for ordinary. So that's the permanent, the right to permanently flood. That's your ordinary. Then above that is the seasonal or the above ordinary. And the interesting thing about that is this was studied thoroughly by the Fisheries and Wildlife and the USGS. And now they used a little bit terminology, but I maintain it's exactly the same thing. They say permanent, semi-permanent. And semi-permanent means that it floods into the growing season, meaning to us that would say that kills terrestrial vegetation. Then they say above that is seasonal, and they define that as flooding that goes away before the growing season. What does that mean? That terrestrial vegetation can grow. So I don't understand. I look at that ordinary high water mark, that 65-foot ordinary high water mark, and I can't see it anything but the navigation servitude that the Corps retained. So what they did was it was originally a navigation project when they were going to raise the Ouachita to 3 feet so it could be 9 feet and deep. They had to raise the pool stage of Darbone. When they raised the pool stage of Darbone, it was going to raise the ordinary high water mark to 65. Well, they looked at that and go, that would be great for a refuge. So they went and bought land all the way there. There's a ephemeral, I think I'm saying that word right, lake, a temporary lake that would come up, and it would go all the way from the shelving on the east side to the shelving on the west side, which is one of the things you're looking for is how you determine where the high water mark is, where's the shelving. And the shelving is on the other side of that ephemeral lake. So it goes up, and it's just wonderful. It's not just a narrow thing. They could have picked where it was very narrow, but they picked a very wide area. They were going to flood it, said, let's make that. So the Corps of Engineers went, now pursuant to making a refuge, bought that land, and then they deeded it to the Wildlife and Fisheries, the very Fisheries and Wildlife. I get that backwards because federal is Fisheries and Wildlife. By doing that, though, the Corps, they agreed with the Fisheries and Wildlife, the ones who made the designations of semi-permanent flooding, that's another name for banks or ordinary flooding. They agreed that this is where it would be. It would be 65 feet would be the navigation servitude. Above that, that's your ordinary. I mean, that's your extraordinary. Your seasonal. So, what that does, it leads to the third question that I have, and that is, did their experts do what the courts require them to do to find the ordinary high water mark? And I submit that they failed to test the restriction that Kelly's Creek says, that you must not use arithmetic. They say it that way. They have another word called arithmetic that they turn it into an adverb, I think. But you can't use arithmetic to do this. And I think if you look at their experts, they talk about grasses and shrubs, but that's not the test. That the banks of rivers have vegetations. They have trees. They just don't have trees that are merchantable. Let
me stop you in the narrative. What's your pathway to reversal of the district court? The district court entered summary judgment, asked you've helped us with laying out all the facts, granted summary judgment, so do you need to convince us that they were not entitled to summary judgment as a matter of law, vis-a-vis, Louisiana law, federal law, or are you arguing to us that there were genuine issues of fact disputes that weren't discernible on summary judgment, so you're wanting a trial? Do you understand my question? I mean, you're giving us the facts, but I think you're going to run out of time if you just give us the narrative. But I want to just, while you're up there, tell us, what is the relief you're asking? Are you arguing that there was an error of law so that summary judgment was inappropriate because they weren't entitled to as a matter of law, or are you just disputing the facts? You had a different view of the facts. The district judge discerned it one way, and as you know, we don't judge the facts. You get me?
I get you.
All right.
I don't think that there is much of an issue of fact. I would say that I think this could be decided even if you assumed what they had to say is true. The only thing they say is that we agreed that it was mowed, and that they say that it was grassy. There was grass, bushes, and trees. I think is the Harrison versus Kite. It is such that was people. The Ford City Quisiquit used in that case. So to answer your question, I think it's mostly a question of law. I think that the facts, we know what they are. How do the law apply to these facts? That's where we are. Okay, and I think that they have used a wrong legal standard that was explicitly rejected in Kelly to come up with this mathematical way of determining it. And when you look at and I still think this is why they did it this way. I think I know they're great lawyers. I've been up against them. They're very good lawyers. Why did their experts not look at terrestrial vegetation versus emergent? Why did they not do that? They were out there. They could go out there. The ground was dry. They could have gone and looked for the line on the bank that showed where terrestrial vegetation ended and where the emergent vegetation was, the land where they could not have that. They didn't do it. They made some measurements. They did two things that I do appreciate. One is they said it was at 55 feet. They found the base of the sign, and they said, okay, that's where it is. So it's 10 feet below that 65-foot servitude that the Corps of Engineers got to permanent flood. The second thing they did was they mentioned and they put into evidence, which helped us, that a code, and in that code, they were talking about persistent vegetation could live there. But more importantly, the very last letter in that code said that was semi-permanently flooded, and you translate that to ordinary flooding, you translate that to the banks.
Well, let me ask you a general question. The illusion occurred where there was dry land 2/3 of the year. Is that correct?
That is factually correct, Your Honor. We do not.
Or how can we say that it's navigable in the ordinary condition if it's dry 2/3 of the year?
Are we talking about navigability in fact here? Because those are two complete separate tests. If you're asking about navigability in fact, now what you're talking about is relevant. The only thing relevant for ordinary high water mark is whether terrestrial vegetation can survive there. That's the difference. If you're talking about navigability in fact, now what you're talking about is very relevant. And if you need me to answer that, the answer is it doesn't have to be year-round. We can tell you this, that I know that when I was a kid growing up in Cameron, the Phyllis McCall is a crew boat. There's absolutely no doubt that crew boat, 3 or 4 months of the year, could start right there and go all the way to Egypt and never get out of that boat. It's not navigable all the time, but it's navigable a lot of the time, and and I will tell you this, just a little bit more of a bump from the Corps of Engineers. If they want to make it the Washita a little bit higher, that'd be navigable anyway, and that's a test too. I think it clearly does show that it's navigable in fact, but Judge, if you're trying to say that that applies to ordinary high water mark, I think that's mistaken. Thank you.
Okay, thank you, sir. You've reserved your rebuttal time. All right, Mr. Diaz.
May it please the court, counsel, my name is Tom Diaz, and together with Tommy Hayes, we represent Kinder Morgan SNG Operator LLC and Southern Natural Gas Company. Judge Wiener, I believe you picked up on the most salient point in this entire appeal. And the question in terms of navigability that is the most fundamental is whether it is land or whether it is a waterway. And you don't even get into some of the nuances of high water marks when, and it's not a mathematical calculation, it's just simply a fact, based on 30 years of data, that this right-of-way is dry land 66% of the time, or 67% of the time. And the question then is never reached of whether that waterway is navigable or not because it is land. So the central issue in this appeal is whether a piece of property, a right-of-way in North Louisiana that is dry land 67% of the time, whether that land, which is mowed regularly by Kinder Morgan, and importantly, to prevent the regrowth of trees, and then secondly, is only covered by water during seasonal flooding, can be a navigable waterway of the United States. And I submit that under Fifth Circuit case law, very clear Fifth Circuit case law among many other fellow circuits, that the answer to that is no. That the question is answered actually not only on this fundamental issue, but one that Mr. Wilkerson brought up a moment ago, that in Parham v. Shoemate, which is a 2007 Fifth Circuit decision, the court unequivocally said that seasonal flooding, and I don't think there's any disagreement on whether flooding is seasonal or not because it occurs during the spring season. And that is exactly what the data illustrated in terms of the right-of-way having water present on it, only during the spring season. But the court in Parham also addressed what Mr. Wilkerson attempted to establish, and that is there being somehow a differentiation between seasonal flooding, ordinary flooding, and pool level, and I'll get into some of the specifics in Parham in just a second. But I believe that that law is quite clear, that Judge Doty did appropriately apply that law to what Mr. Wilkerson concedes to be uncontested facts here, and that right-of-way simply is not navigable. Now, in the court below, there were 3 different attempts to try to fashion this right-of-way as being navigable. And one was to say, or more importantly, whether this pipeline sign was an obstruction to navigation, and the first argument, seemingly abandoned on appeal, is whether it was part of Bayou D'Arbonne. But our expert, Dr. Paul Kemp with LSU, established going back to Louisiana's incorporation in the United States back in the 1830s, that Bayou D'Arbonne was depicted as a meandering bayou. For 100 years after that, it is continually viewed as a meandering bayou. In 1957, which is a very important date when the GLO comes in and maps Bayou D'Arbonne, because 1957 is about 7 years after the right-of-way was created. after the right-of-way was cleared and the pipelines were put in place, and the GLO, in depicting Bayou D'Arbonne, noted it as being distinct from the right-of-way, and the right-of-way simply intersects with that bayou, which has been in a traditional bayou that flows through north of Monroe. In 1969, that depiction was photo-revised by the Wildlife Service, the Geological Service. Likewise, the right-of-way is an intersection with, not a part of Bayou D'Arbonne. And the pipeline sign couldn't be an obstruction to navigation of the bayou. And indeed, where else is Kinder Morgan going to put that sign in order to warn boaters on Bayou D'Arbonne not to anchor or dredge when it is that area of the bayou that almost 70% of the year has a permanent water stationed on it? And it's over that water body that vessel traffic takes place. And it can only be in that area that a pipeline sign can warn boaters on the bayou of the existence of a pipeline sign and not to anchor or dredge. The second issue, which I think is legally unfounded, is whether based on the Daniel Ball or the CFRs, back to your original issue, Judge Wiener, is whether it's a waterway period. When you have 70% or 67% of the time it is dry land, it is mowed regularly, and the specifics of Kinder Morgan's declaration before Judge Doty is important here. It's mowing to prevent the regrowth of trees. And I don't think that there is any colorable argument to make that trees are not terrestrial vegetation. On either side of this right-of-way are hardwood trees that cannot exist if permanently flooded. So there is not an issue of fact in terms of whether terrestrial vegetation exists along the right-of-way. It exists to the point where it has to be mowed so that trees don't grow and roots ultimately descend down to the pipeline.
Does the record reflect what kind of trees are being prevented? What were they? Oak trees, cypress trees?
They're not cypress. They are classified by Dr. Kemp as being hardwood, and distinct from those that exist in permanent water bodies. I can't remember specifically off the top of my head, but it was addressed. And it was addressed in terms of what was removed from the right-of-way and what continues to exist on either side of the right-of-way today. And that seasonal flooding doesn't prevent the growth or the continued existence of that hardwood, which unquestionably is terrestrial vegetation. Now, I mentioned a little bit earlier about this court in Parham v. Shoemate establishing the affirmance of Judge Doty here. And in that decision, the court echoed other fellow courts in stating unequivocally that the navigational servitude does not burden land that is only submerged when the river floods. And in that case, they were dealing with an issue of trespass on the Gassaway River in East Carroll Parish. And the fishermen said that they had a federal right to be on that waterway because they could traverse it in their boats due to floodwaters from the Mississippi River. And the Fifth Circuit said unquestionably you cannot consider the seasonal flooding on the Mississippi River and its effect on the Gassaway Lake to establish navigability, which did not exist. And in fact, those fishermen were trespassers. And that is also mirrored, I think, factually a bit more analogously to the case that we have here in, it's kind of an odd pronunciation, but it's out of the Ninth Circuit, called the Ponderay Public Utility District. And that case and that appeal, I think, disabuses the court of the notion that a 65-foot navigational servitude unexercised is irrelevant to this appeal. Because in Ponderay Public Utility District, there was a development by a water district where they put a dam in place which raised the pool level of a river from 2,022 feet to 2,032. Flood levels reached 2,041. And the flood district said, we have a navigational servitude to 2041 and therefore don't have to compensate the Native American tribe when we flood their land. And the Ninth Circuit said no. The Ninth Circuit said the federal case law is consistent with with that of Washington State, and both mandate the exclusion of annual spring floods and calculating the high water line. So that is quite clear with respect to the Ninth Circuit, and likewise cited in Ponderay are other decisions cited by the Fifth Circuit for that proposition that seasonal flooding is excluded, and those are United States v. Claridge, Borough of Ford City, likewise said unequivocally. And Borough of Ford City is worth noting because it does not support what the plaintiffs contend, and in fact excludes from a navigational servitude in the definition of navigability, the bed of the stream does not extend or include that upon which grasses, shrubs, and trees grow, though covered by the great annual rise. And then the last issue that the appellants raise is the 65-foot right to flood never exercised by the Corps with respect to the Darbone Refuge. And I think it is worthwhile. I embedded some of these photographs in our brief so you wouldn't have to leaf through the record to see what would happen to the Darbone Refuge were it to be flooded to 65 feet, which it has never been, at least by the Corps. It has by annual rises on the Ouachita River, but not by the Corps, and effectively the refuge would become a lake. That every water body that is depicted individually within that depiction of the refuge disappears. And there is no Bayou Darbone anymore. And were the Corps of Engineers to exercise that right, it would have effects far beyond the refuge. It would impact riparian rights. It would impact, personal property ownership rights. But the Corps has never exercised it. What the Corps has done with the Columbia Lock and Dam project is to raise the water level from 5.5 to 9 feet on the Ouachita River, which has slightly raised Bayou Darbone as a result, and no more. And every amount beyond that is seasonal flooding only. And I'll leave you with this thought, because I don't need to occupy my entire time, but on the first point that Mr. Wilkerson raised, and that is we have this demarcation of pool level, ordinary flooding, and extraordinary flooding. And the Fifth Circuit in Parham says any flooding, seasonal, which is exactly what happens here, does not define the extent of a navigational servitude or define a navigable waterway. But importantly, in footnote 4 of Parham, the Fifth Circuit said Louisiana law and federal law are different. Louisiana law, in terms of this alluvion exemption in order to create levees, created an exemption when you can dredge out alluvion in a river, which would be part of the navigational servitude, and that would be exempt from a compensation to private landowners. And in footnote 4, the Fifth Circuit said, no, there's a distinction. That while alluvion is created during flooding, because you have accretion of property on the side of a river, which can be taken without compensation, federal navigational servitude is different. And it does not extend to floodwaters. And it is uncontested below that the only reason, it's a tragic accident, but the only reason that it took place where it was, because otherwise it is 67% of the time dry land, is because of seasonal flooding on the Ouachita River as it affects the refuge. And as a result, the parties agree that if this is land, it's subject to Louisiana law and the Louisiana Recreational Use Statute. And as a result, immunity applies. Judge Doty correctly concluded that that is the case here, and I would ask that the court affirm.
All right, thank you, Mr. Diaz and counsel. Back to you, Mr. Wilkerson, for a rebuttal.
Your Honor, a couple of real quick things. First of all, trees can grow on banks. They're just not merchantable trees. One example is an overcup oak that can grow on banks. I'm not an expert in it, I just know that that's a fact. But let's say this, that nowhere ever in the record, not in any of the the three experts, nowhere do they say anything merchantable grew there. That anything that was useful for agriculture grew there. Talking about at the point of the lesion. That's the first thing I wanted to say. And our experts said nothing could grow there. They did not, absolutely did not present any evidence to overcome that. The next thing they mentioned, Parham and Pinned, they say exactly what the court did, but what they didn't tell you is that they said what seasonal flooding was, and that's flooding that did not kill agriculture. So Penn is very consistent with what we argue, and that is seasonal flooding is that point where terrestrial vegetation can no longer grow. Parham, Your Honor, I would say that case is not even applicable. What happened in Parham was they were wanting to fish, and fishing is not allowed under the federal navigation servitude. You can't fish there. It didn't do them any good to put on evidence, and in fact, if you read Parham, it says absolutely that no evidence was even put on about the ordinary high water mark. Why? Because it didn't help the plaintiffs to put on that they were on the banks because they still couldn't fish. They wanted to fish. That was their ultimate goal. So I would say that Parham, even though it also defines ordinary high water mark with the vegetation test, Your Honor, every single case says it. Every case ultimately, they may lose it to district court, every case says ordinary high water mark is where you can no longer have terrestrial vegetation. He talked about some policy matters, and I meant to get to these things. If we limit the Corps' servitude to that bank, it goes straight up like this. All of what used to be the banks where they do the controlling and navigation, where they could cut trees or they could do things to make navigation better, that's on the banks. So the ownership is the riparian owner, but there's a servitude that the federal government has to flood it, to destroy it, to take out your piers, take out your docks. It's theirs. So even though the riparian owner owns it, they don't have much rights. Most of the rights belong to the feds. Okay, if you take that away, now all of a sudden they own the water and the land, the riparian owners. They could keep you off there if you're riding down there and all of a sudden your boat breaks, you can't go into there, you can't ride on it, you can't do anything. You'd be stuck to just that channel. And there's no way the servitude is supposed to be long and wide and allow the federal government to be able to control it. What keeps it going those distances that they're talking about is apply the test. Every time in Harold, there was a Corps engineer guy who quit applying the test. He said, well, if it goes to ordinary high water mark, everything covered. Well, they know it's not killing terrestrial vegetation. And in Harold, they go, no, you got to stop it there. That's what keeps it from going out. So when Harold says it can go on forever, how do you stop that? Look at the test. That's how you stop that. So I wanted just to say this, that the way you do it when you have a navigable water body, the way you do it is you look for the banks, and the banks are where terrestrial vegetation ends. It's that simple, every single case, no matter what the ultimate result was. And I know I got to conclude. I do appreciate your time, and I do coach high school baseball, so sometimes I get a little, but I don't mean to be. I apologize for that in advance. The Corps has that right to flood to 65 feet. They retained it. The people who know where that ordinary high water mark is, that seasonal flooding area, if anybody knows what that is, it's the Department of Fisheries and Wildlife. They're the ones who put all those codes on there and determine it, and they agree with that number. They agree with that 65 feet. The pipeline companies did not put on any evidence whatsoever of where that line was. They went to statistics, and that is not allowed under Kelly. What they want to do is say this is normal because 67% of the time. No. How long was it how long was the water on top of that property during the growing season? And that is unequivocally 65 feet on that lake, on that bayou, and where the refuge is, and especially where our property was, where our expert said, sorry, thank you, Your Honor. I'll wrap it up like that. Appreciate your time.
Problem. Okay, thank you, counsel. We appreciate the helpful briefing, the photos, and the rest in the oral argument. The case will be submitted along with the other case that was argued.